Welcome, everyone. This presentation is just about general information on the Americans with Disabilities Act, the ADA, and about reasonable accommodations specifically for employment. The presentation is general information. It is not legal advice, and we won't be able to help you with a specific situation or specific problem, although I do hope you find this information helpful in applying to your specific situation. We'll have an opportunity for questions at the end of this presentation, but we won't be able to answer any questions about specific informations. We'll only be able to clarify about the information presented here today. So at the end of this presentation, I'm hoping that you'll have the answers to all of the following questions. Who can ask for a reasonable accommodation? Why do reasonable accommodations exist? What is a reasonable accommodation? When can you ask for a reasonable accommodation? And how can you ask for a reasonable accommodation? I also think that a really important piece of information that you should be able to take away from this webinar is what to do if your reasonable accommodation is denied or isn't working out. So we'll share that information with you as well. So who can ask for a reasonable accommodation? Well, to answer that question, we need to know a little bit about the Americans with Disabilities Act in general. The Americans with Disabilities Act has several parts to it. Title I, Title II, Title III, Title IV, and Title V. And each of these different titles deals with a different area of disability rights. And so since we're talking about employment here today, we're going to be primarily talking about Title I of the ADA. But we also will touch on Title V, because in those miscellaneous provisions, that's where retaliation in the employment context is covered. So we know that we're going to deal with Title I in employment. And Title I protections make it unlawful for employers to discriminate against people with disabilities in all aspects of their employment. So this includes recruitment, hiring, training, job assignments, promotions, benefits, as well as things like layoffs and firings. So these protections generally are also supported by the addition of reasonable accommodations and the right of people with disabilities to ask for reasonable accommodation in their employment. So how do you know if you qualify for coverage under Title I of the ADA? Oh, I'm sorry. So as I said before, retaliation and also coercion are also illegal under the ADA, and that part comes from Title V. So if you ask for a reasonable accommodation and are then subject to any type of adverse employment action, whether that's termination or whether that's something like a cut in hours or pay, that's an unlawful retaliation. And it's also unlawful for your employer to threaten to do any of those things in retaliation for you trying to assert your rights under the ADA. So how do you know if you're protected by Title I? Well, there are two conditions that have to be met. The first condition is that your employer has to be an employer that is covered by the ADA. The second condition is that you have to be a qualified individual with a disability as defined by the ADA. So what do these terms mean? Well, a covered employer could be a public employer or a private employer that has a minimum of 15 employees. So that's fairly straightforward. What's not as straightforward is the definition of a qualified individual with a disability. There are a few different definitions that are used by the ADA. The first definition is what we call the definition of actual disability. This definition is someone who has a physical or mental impairment which substantially limits a major life activity or bodily function. So for instance, we've got Lisa here who uses a wheelchair. That seems like it's probably a physical impairment, which substantially limits the major life activity of either standing or walking or both of those things. On the other hand, we've got Tammy who has seasonal allergies, and Tammy would probably not be covered under the ADA because that's unlikely to be a substantial limitation of a major life activity, even though that is, clearly a physical impairment. If everybody will hang on for just a second, I am going to turn on my video just to make it easier for people to see. Hopefully, I'm sorry about the quality here. It's a little dark where I'm at, but hopefully people are able to see this now. So that's the first way that you can count as a qualified individual with a disability under the ADA. The next way that you can qualify as an individual with a disability under the ADA is by having a record of a disability. So even though you might not currently have a substantial impairment, it might be that you had one in the past and you've since gotten successful treatment for that, or it went away on its own. And so even though you don't now, you used to, and your employer is aware of that. The third option is what we call the regarded as prong. And this is somebody who your employer might think that you have a substantial limitation, but you don't actually. This is just a misconception by your employer. So in this case, your employer is treating you as if they think you have a disability, when in fact you do not, and you don't have a record of a history of having this. So those are the three definitions for an individual with a disability under the ADA. And you don't have to meet all three of those definitions. You only have to meet one. It's also important to note that when we're talking about a qualified individual with a disability, that word qualified is in there. This means that somebody who is an applicant for a job or an employee has to be able to perform the essential functions of their job without reasonable accommodations or with reasonable accommodations if that's needed. It's also important to point out that they need to possess the skill, education, and certification or experience necessary for the job. So obviously you have to have whatever appropriate training and expertise is necessary for that job. So I thought that an easy way for us to figure this out is by looking at some examples. So here we've got our first example, which is Hakeem. Hakeem works at a bakery. His parents own the bakery. He's 26 years old, has type 2 diabetes, and does not have a food handler's certification from the state. Would Hakeem be protected by Title I of the ADA? Well, let's look at some of the facts that we have here. First off, we know we need to have a covered employer. The facts we have about his employer are that it's his parents and a bakery. What we don't know is if there are at least 15 employees at the bakery. If there are 15 employees, then it's a covered employer. If there aren't, then it's not. What type of business it is doesn't matter, and the fact that his parents own this also doesn't matter. Then we need to know if Hakeem is a qualified individual with a disability. We can see that his age is irrelevant to this question, but we see that he has type 2 diabetes. So we know that's a physical impairment, which substantially limits, in this case, a major bodily function. In this case, his body's ability to produce and regulate insulin. And then we have to know, is he qualified? We see that he doesn't have a food handler certification, but we don't know what it is that Hakeem does at the bakery. Is he a baker? Is he a cashier? Is he a waiter? We're not sure. So we have to know the answers to all of these questions in order to be able to answer whether or not Hakeem would be protected by Title I of the ADA in this situation. Let's look at another example. Kaylee. Kaylee has severe anxiety. She also sprained her ankle last week. The doctor said she can use it, but it won't be healed for 2 weeks. She works for a public school as a teacher, and she has a master's degree in education. So is the employer covered? I think probably the employer is covered. A public school likely has more than 15 employees. And then does Kaylee have one of those definitions of disability? Well, let's look at the ankle. Is that a physical impairment? Yes. Is it substantially limiting a major life activity? Well, maybe not. She can use it, so probably this isn't really a substantial limitation of a major life activity, even though it'll take a while to heal. But if we look, we also know that she has severe anxiety. So that's a mental impairment. And because it's severe, we know that this was probably a substantial limitation on a major life activity. In this case, that activity would be thinking. So, and then we see that Kaylee is clearly qualified for her job. She has a master's degree in education. So in this case, Kaylee would be protected by Title I of the ADA. But it's important that we know why that is. And it's because of her severe anxiety and not because of her sprained ankle. Here's an example. Lynn had breast cancer last year. She had to go on leave for her treatment, but now her cancer is in remission. She's cancer-free and she's back at work full-time. She works as a receptionist for a large Fortune 500 company, and she's done this job for the last 8 years. Well, we know that this is going to be a covered employer because I said it's a large company. We know that she is a qualified individual with a disability because while she doesn't have a current impairment, we do see that she had a record of an impairment. And that her employer knows about the history of her disability because obviously she had to go on leave last year. And we know she's qualified because she's done this job for the last 8 years. So we know she's capable of doing these essential functions of the job with or without a reasonable accommodation. And in our final example, Rhea works for a small tech startup. She wears glasses because her vision isn't good, and she plans on quitting to get a job in finance and banking. And she has a degree in computer sciences and technology. Well, is this employer covered? Small tech startup? Maybe that's 15 employees, maybe it's fewer. It might not be a covered employer. But whether or not it's a covered employer, Rhea still has to meet the definition of being a qualified individual with a disability. And wearing glasses because her vision isn't 20/20 isn't going to meet that standard. So we know that she's not going to be covered by Title I of the ADA. Now, vision impairment, if it's severe enough, is covered by the ADA. But typically being simply an eyeglasses or contact lens wearer is not enough to rise to that level of counting as an individual with a disability under the ADA. So in all of these examples, we can see that we need both of these elements here, a covered employer and a qualified individual with a disability. But these are just the ingredients that we need for protection under Title I of the ADA for all of those things we listed. There's actually a much smaller category, a subcategory within these of people who are able to actually request a reasonable accommodation from their employer. But before we go on to that, we need to know about this last way to be covered by the ADA. The ADA protects you if you're a victim of discrimination because of your relationship to somebody who meets one of those definitions. So if you have a spouse or a child with a disability, then you're protected from discrimination because of your relationship to them. However, as I said, not all of these definitions that give you protection under the ADA allow you to request a reasonable accommodation. So if you're going to request a reasonable accommodation, you're only able to do that if you're protected by the ADA because of your actual disability or because of your record of a disability. But if you're merely regarded as disabled by your employer, or if you're using the association exception, that relationship with somebody with a disability, those two protections apply to discriminatory actions by the employer, but don't entitle you to ask for a reasonable accommodation. So you have to make sure that you have a covered employer and that you're falling into those protections under the ADA because of the actual disability definition or the record of an actual disability definition. So those are the things that allow you to ask for a reasonable accommodation. So now we're getting to the next question. Why do reasonable accommodations exist? And the answer to that is pretty straightforward. The entire ADA was enacted to help provide equal opportunity and equal access to individuals living with disabilities compared to individuals who are not living with disabilities. So it's meant to specifically overcome the limitations of that disability and create an even playing field between workers who are disabled and workers who are non-disabled. So all a reasonable accommodation is doing is filling in that gap that's created by whatever the specific limitation of the disability is. And now we're really getting into the heart of this. What is a reasonable accommodation? And it might seem pretty straightforward. I'm sure we can all think of some examples off the top of our heads, but there are a lot of nuances about what it can be and can't be. So in the most basic sense, a reasonable accommodation is any change in the work environment or in the way that things are customarily done that enables an individual with a disability to enjoy those equal employment opportunities that I was talking about. So this could be the addition of something like giving you a chair or a stool to sit on, adding a ramp for a wheelchair or a handrail to hold on to. It could be the removal of something from the environment. So, if you've got light sensitive migraine headaches, the subtraction of light, or if you have a fragrance sensitivity, creating a fragrance-free area, or removing an allergen if you have, for instance, a severe peanut allergy. And of course, it can also be a modification of a policy. For example, if there was a policy that everyone has to stand to greet a guest, well, that isn't going to work for someone who's unable to stand. And so an exemption from that regular policy is another example of a reasonable accommodation. Now, let's talk about what an accommodation has to be, what it can be, but doesn't have to be, and then what it can't be. So an accommodation must be effective. So does the accommodation adequately overcome the individual's specific limitation due to their disability? And sometimes one accommodation or modification isn't going to be enough to overcome that specific limitation. So it might require multiple accommodations or modifications in order to get to that point where it's effective. But if it's not effective, obviously it's not helpful. So an accommodation has to be effective. Now, it can be the best type of that accommodation, but it doesn't have to be. So, I like to think about this as a Ferrari versus a beat up used old Toyota. Um, they're both going to be able to get you on the road driving to where you need to go. But obviously one is clearly more expensive, higher performing, better than the other. But your work doesn't have to provide you with the Ferrari of accommodations if there is a beat up old secondhand Toyota of accommodations that they're able to provide you. So for example, if you need a piece of adaptive software and there's two that are going to work, but one has additional features, your work isn't required to provide you the one with additional features, provided, of course, that the one that doesn't have the additional features is still effective. So the accommodation also doesn't have to be the one you or your doctor asked for. Typically, it's a good idea because you and your doctor are going to be in the best position to know what will be effective for you. But as long as your work can find a different one that is going to be effective, it doesn't have to be the one that you request. Now, here are the things that an accommodation does not have to be. It does not have to get rid of any of the essential functions of the job. It does not have to be provided if it's going to be a direct threat to yourself or to others. They don't have to provide you with a personal device or lower production standards that are applied to all employees. It doesn't have to be a change in your supervisor or excuse a violation of conduct rules. And lastly, it doesn't have, it can't cause the employer undue hardship. So this is a long list. So let's break it down and see each of these. So the accommodation can't get rid of the essential functions of a job. And, I mentioned earlier that a qualified individual with a disability is someone who's able to perform those essential functions of the job with or without a reasonable accommodation. So how do we know what an essential function is? Well, there are essential functions that are core to the position, and there are marginal functions that aren't really important. And here are some of the different ways that we can figure out if an essential function or a marginal function is what we're talking about. So does the position exist specifically to perform that function? Are there many employees who could take over that type of responsibility? Or is it just you? And if you don't do that responsibility, nobody will. Is this a piece of your job that requires a certain skill set or expertise or training? Or is it something that anybody can do? Do other employees with the same position do that type of thing in their job? Or is it not something that's been required of employees in the past? How much of your day is spent performing that function? Is it just something that you do for 10 minutes every day? Or is it the bulk of your job performance? And then what happens if you aren't required to do that? Will the company lose customers or be hurt in some way? Or is it really not that important? And then, of course, what are the terms of a collective bargaining agreement, like a union agreement? So if we look at, for instance, a customer service example, there are some things that could be essential functions and some things that could be marginal functions. If our customer service representative works in a large call center and all of the call center employees take a turn each week to clean the break room, what happens if one employee isn't able to do that? Well, we can see that there are probably lots of employees at the call center, so plenty of people to distribute that task to instead. It's not something that requires a special amount of skill or expertise. It's certainly not the reason that the call center representative position exists. It's not to clean the break room. It's to take the calls, respond to emails, and know the company's policies. The consequences of not cleaning the break room are just a messy break room. It's not like they're going to lose customers or get a bad reputation. So when we look at these things, we're able to sort of balance all of these different factors and determine which of these are important, essential functions, and which of these are sort of marginal, lesser functions that are easily reassigned to somebody else. But it's not always as clear-cut as this. If we take the example of a doctor or a nurse performing CPR, being able to hear through a stethoscope, knowing about patient privacy, and being able to lift 50 pounds, all of these things are things that might or might not be an essential function. For example, performing CPR, if you don't or aren't able to do it or don't know how, that could have some pretty serious consequences. But depending on the type of doctor you are, that might not be something that happens very frequently. If you're a doctor who works in the emergency room, performing CPR is probably a pretty critical, essential function. But if you're just an ear, nose, and throat doctor who works on non-emergent cases, the likelihood that you're going to have to perform CPR is probably a lot less. So, even though there's big consequences to not being able to do it, how frequently is that going to happen? And is there somebody else there at the hospital or at a private practice who's able to perform CPR instead? A different nurse or doctor or an orderly, something like that. Same with hearing through a stethoscope. Now, if we look at this, knowing about patient privacy and following patient privacy rules, that's probably going to be critical for any healthcare professional. So likely in any setting, that one will be an essential function, even though the other ones might go either way to be a marginal function or an essential function. So you can see with these examples that what an essential function is and what's a marginal function that's able to be distributed to somebody else is going to be really fact specific. It's going to be very dependent on your own situation. So I recommend that everybody spend some time after this webinar just writing down the things that you do with most of your shifts at work, what the most important things you do are, who else could do those things, and sort of try to figure out what you think the essential functions of your job are versus what the marginal functions are. Now, the accommodation can't be a direct threat to yourself or others. So the company has no obligation to accommodate you if there's a direct threat that can't be mitigated. And I think that something that a lot of people will think about immediately here is the very common example of someone who is prone to seizures or who has epilepsy and the operation of heavy equipment. However, it's important to note that a direct threat has to be a significant threat of substantial harm that can't be eliminated or reduced by a reasonable accommodation. So when I gave that example, that's a stereotype, and it has to be based in an individualized assessment, not a stereotype, because there are plenty of people who are prone to seizures or who have epilepsy, who are conditions are under control and are able to operate heavy machinery. And so when you're doing this individualized assessment, an employer must consider the duration of the risk, the nature and severity of the potential harm, the likelihood that the harm will occur, and how imminent that harm is. So it's important to know that a direct threat can't be used as a denial for a reasonable accommodation if that accommodation is going to reduce or eliminate whatever threat was posed. I also think it's important for people to note that this direct threat can be not just a threat to others, but a threat to self. So for example, if you have a doctor's note and the doctor's note says that you are not able to work, then your employer is not able to second guess that doctor's note and say, well, I actually think you are able to work, because they can't put you at a significant threat of substantial harm to yourself. Unless, of course, there's an ability to mitigate any of those risks through a reasonable accommodation in returning to work. An accommodation can't be a personal device. So your employer isn't required to provide you with something that you use in your day-to-day life outside of work. So these are things like hearing aids, wheelchairs, canes, or even service animals. Now, your employer needs to be able to let you use your personal device in the workplace, but they're not required to pay for or obtain these items for you. And this is a pretty easy test. It's fairly easy to tell if something is a personal device because you use it at home and in other areas of your life as well as at work. An accommodation can't lower production standards that are applied to everybody. So an example of a production standard might be the number of calls that our customer service representative needs to take per week, or the number of items that a warehouse worker scans per hour, or the number of errors in an audit period. And the theory behind this part of the law is that the company is setting these production standards in order to stay profitable. And if the company isn't profitable and isn't able to do their basic functions, then obviously that's a problem for the company. So these are some examples of a production standard. And as long as you can meet that production standard with a reasonable accommodation, that accommodation should be granted. But the accommodation does not have to cut or lower what those production standards are. I said earlier that an accommodation can't be a change to an employee's supervisor. However, it is possible for an accommodation to be a change in the supervisory style. So if the supervisor is prone to yelling and you have post-traumatic stress disorder, you can ask for a change in your supervisor's style to approach you in a calm manner. Or if the supervisor tends to give important instructions in passing and just mention them, but you have issues with your memory or attention, then you could ask for your employer to write out a memo and give you those instructions in a written format as well as verbally. And that would be a changed supervisory style, even if you can't change who the actual person supervising you is. An accommodation doesn't have to excuse a uniformly applied rule of conduct. So rules of conduct typically include workplace violence and harassment policies. It can include dress codes, inappropriate language, and then alcohol and drug use on the job. So there's no free pass on any of those types of things. However, it's sometimes a workplace code of conduct, particularly a dress code, may not be written to be disability friendly, and there is some leeway there. For example, if you had a prosthetic foot that doesn't work well with a dress shoe, it would be very reasonable to ask for an accommodation to be able to wear a sneaker instead. But as a whole, those rules of conduct, as long as they are applied to everybody, can't be an exception for somebody who needs a reasonable accommodation. And then finally, the accommodation can't cause the employer undue hardship. Typically, what this ends up meaning is that if the accommodation is extremely expensive and beyond the employer's means to provide, then that would be undue hardship. But it could also mean if the accommodation requires drastic restructuring of the day-to-day business operations or something like that, that might also be undue hardship. And it's important to know that when we're evaluating what is and isn't undue hardship for your employer, we have to look at their entire resources. So what's an undue hardship for a very small employer that doesn't have a lot of revenue will be very different than what's undue hardship for a very large employer that has a lot of revenue. So when we're talking about reasonable accommodations, these can be a range of things. And here are some of the most common ones. Making a facility accessible. So that's, the ramps, handrails, things I mentioned like that before. It could include the addition of ergonomic furniture in an office setting, things like that. Part-time or modified schedules. Like I said before, this is all going to be very fact specific. So if the call center that we've been talking about has calls coming in only 4 hours a day, it's probably pretty critical that everybody show up for those 4 hours to make sure that the calls are taken. However, if the customer service is happening via email, and it could happen anytime during a 24-hour period, a modified schedule would be really easy to accommodate. And so it'll really depend a lot. So most of the situations that we encounter are going to fall somewhere between those two examples. Maybe the call center operates from 8 a.m. to 8 p.m. And during that 12-hour window, it's important that there be enough employees there to answer calls. But there also, needs to be an accommodation for an employee who needs somewhat more flexibility. So a situation will probably fall somewhere between those. And in most cases, there is some sort of flexibility that's able to be accomplished. It's also important to note that the type of flexibility should be hinged on what the limitation on that disability is. So, for example, if you have irritable bowel syndrome and you need an extra long bathroom break, you might need that to happen sporadically throughout your shift. And that's the type of flexibility you need. However, if you need to see a regularly scheduled neurologist, the type of flexibility that you need will be to go to a specific appointment. And so that likely won't be a day-to-day flexibility. And maybe your manager asks you to schedule that for a certain day of the week when they know that the call volume is lower, for example. There can also be accommodations related to tests, training materials, and policies. Maybe that includes providing those in a Braille format or giving them verbally instead of in a written format. Providing a qualified reader or an interpreter can be a legitimate accommodation. And then flexible personal leave policies can be one of the most difficult types of reasonable accommodation to figure out with an employer. And the reason why is because going back to that initial definition, with the reasonable accommodation, you have to be able to perform the essential functions of the job. So if you need indefinite leave with no date that you're able to return back to work, that might be a really difficult position to put your employer in, because you obviously aren't able to do the essential functions of your job if you're not there to do your job, if you're on indefinite leave. However, if you need just intermittent leave every so often, or if you need leave that has a definite end date, those are more legitimate types of reasonable accommodation that the employer should be able to grant or work with you on. And then finally, reassignment to a vacant position is an option if there's no other accommodation that allows you to do the essential functions of your job. So if you're no longer able to do those essential functions, even with a reasonable accommodation, your employer should look for a vacant position for you. They don't have to create a new position, but if there is a position that's already open, then you should be reassigned to that position. However, there are a couple of caveats to that. One caveat is that if the open position is a promotion or above the level that you're already at, they don't have to give you a promotion simply on the basis of your disability. However, if there is an open position that is at your level or below your level that you're qualified for, then that reassignment should happen, provided there's not a different reasonable accommodation that will allow you to perform those essential functions of your job. It's also important to note that most accommodations don't cost very much. And your employer might be surprised to hear this. 50% of accommodations cost less than $500. 19% cost nothing at all, and 80% cost less than $1,000. So on the whole, most accommodations are extremely cheap. And I think that this is a good fact for you to have to bring to your employer if they're concerned about the cost of a reasonable accommodation. Now, this is probably the piece that's most critical for people joining us here on this webinar. When can you ask for a reasonable accommodation? Well, at any point. A reasonable accommodation could be in place when you're applying for a job. If you have dyslexia and the job requires a written statement, you could ask to instead do it as a recording. When you're interviewing, if the interview needs to take place and you need an ASL interpreter, you can ask for that interpreter for the interview. That's an accommodation to their interview process. After being offered the job, after you've been working there, really a reasonable accommodation can happen at any point. But how do you ask for one? Well, you kick it off with a request for the reasonable accommodation by including two things in your request. One, you have to include that you're asking because of a medical condition or disability. And then second, you have to make it clear that you're asking for some sort of change. There are no special magic words that change just anything into a request for reasonable accommodation. You don't have to say reasonable accommodation. You don't have to say your specific disability. And you don't even have to put this in writing. But you do have to make sure that it includes those things. So an example that I like to use is saying, hey, I need a new chair because of my back. Does that rise to the level of a request? Well, it might, but it doesn't exactly say everything that's needed. What about your back makes you need the new chair? It doesn't quite put it over the edge, but maybe if you said, I have a bad back and that's why I need a new chair. Now that might tip it over into being a request for a reasonable accommodation. So it's important to make sure that your employer is aware that what you're requesting is based on a medical condition. Now, just because you can make the request for a reasonable accommodation verbally doesn't mean that that's the best way to do it. I always prefer it to be in writing whenever possible, because that obviously allows least room for interpretation or confusion on your employer's end. Once you've initiated, once the employee has started the process by asking for a reasonable accommodation, then we're into what's called the interactive process, which is a back and forth between the employer and the employee to figure out what the reasonable accommodation should be and how to implement it. So some things that might happen during the interactive process are the employer might direct you to an established process for requesting an ADA accommodation. If you just mention something like, I need a new chair because of my bad back to your manager, maybe they'll send you to HR or give you specific forms. Or maybe your company has a third party company that they use to evaluate all of their ADA requests. Well, your employer is allowed to direct you to that appropriate process. They might also ask for medical documentation. This is appropriate only in cases where either your disability isn't readily apparent, or if it's not readily apparent how the accommodation you're requesting is related to that disability. Your employer might not have an immediate answer, a yes or a no, on your request. And the employer might want to try out some different options. And this sort of goes back to that idea that we were talking about earlier with the Ferrari versus the Toyota. The employer might want to see if there's something that could work out that it doesn't cost as much or doesn't take as much manpower to set up, something like that. So there are pieces in this interactive process that can be uncomfortable and difficult to work with, because it can be really frustrating to submit a request for reasonable accommodation that seems pretty straightforward, and then have your employer not have an answer ready, or try some things that you didn't ask for, or send you a lot more paperwork. So all of those things can happen, but they don't necessarily mean that your reasonable accommodation is being denied right away. So here are some tips and tricks that I like to point out. First off, when you're asking for an accommodation, do try to have something in mind that you know will work. And one resource for that is the Job Accommodation Network. Their website is askjan.org, askjan.org. And that website allows you to search by disability or by limitation, and to work with specialists to come up with ideas for specific accommodations for your specific disability. And they're also a resource for your employer. You can ask your employer to go on askjan.org or to work with a job accommodation network specialist to figure out if there's an accommodation that can work for you. Always document your communications and correspondence with your manager or your HR representative, whoever's handling the request for accommodation. You can also get support and advocacy from job coaches, friends, family, other people who are able to come up with ideas for how to accommodate your disability. One critical thing here is not to assume that your employer knows that you have a disability. Frequently, people mention in passing to their coworkers that they might have a disability and assume that their boss or manager knows, but that's not always the case. And so that's one of the reasons that I think that putting things in writing is really, really helpful, because it shows that your employer knows that you have a disability. Another thing that you can do is, if you are going to provide medical documentation or are asked for medical documentation, work with your doctor to make sure their letter is helpful. A lot of times a doctor's letter just says something like, so-and-so has this disability and they should get, a new chair for it, or whatever the accommodation that you're requesting is. But a helpful letter will really explain what the limitation that's being overcome is and why you need that. So make sure that the letter isn't just reiterating what you've already told the employer. Make sure that it's adding something for your employer to work with. And then if your employer might not have an answer for your accommodation right away, go ahead and ask for a temporary accommodation. Say, listen, while you're waiting to figure out if you've got approval on the funding for my new chair, could I work from home this week where I have a chair that will accommodate my needs? And then at the end of the week, we can see if I'm able to come back in because you've got the new chair. Something like that. That way, the period while you're waiting to have a final answer on your accommodation it isn't a hardship for you. So if you've followed all of this and gone through and requested an accommodation, what happens if that accommodation is denied? Well, there are some informal options for you to go through. Hopefully, from the information in this presentation so far, you're able to have a bit of an idea about why your employer denied your request for accommodation. It could be because you were actually asking for something that was an essential function to be removed. Maybe it was because your employer thinks it's an undue burden and too expensive. If you're able to figure out the reason that they are denying it, then you're able to articulate why you disagree. And you can say, I don't think that this is too expensive, given that you are a very large company with tons of resources. And in fact, most accommodations cost under $1,000. I think that if you want to go ahead and let your work know why you're disagreeing with their denial of your accommodation, it's best to do that again in writing and specifically articulate why you think that your accommodation is reasonable and could happen, and where they went wrong in their reasoning. If they've denied your specific accommodation, go ahead and ask them for reassignment or for a different accommodation. Say, this isn't just an opportunity for you to say yes or no to the thing I'm asking you for. This is an opportunity for the employer to engage in that interactive process and figure out if there is something that could be effective, and make sure that reassignment is on the table as an option if there are any vacant positions or vacant positions that are going to open up relatively soon. It's also helpful to get somebody else involved. It could be your union representative, a job coach, maybe a lawyer or a family member. And you can always make a report to human resources or file an official grievance with your management to say that you think that your reasonable accommodation was illegally denied in violation of the ADA. It's important to note that you can also make that report to HR or file a grievance if you think you're being retaliated against or pressured into not asking for a reasonable accommodation. So those are all informal options that are easily available to you and are ways to work out the situation with your employer. If you've already tried all of these, or you don't think that these options are going to work for your situation, there are some legal steps that are available to you. In many parts of the law, the way that the law is enforced is through a lawsuit. However, in disability-based employment discrimination, you're required to go through an administrative process first before you're able to bring a lawsuit. And there are two administrative processes available to you in the state of Utah. One is going through the state agency, the Utah Anti-Discrimination and Labor Division, the UALD, and the other is going through the federal counterpart, which is the Equal Employment Opportunity Commission, the EEOC. And you can file a charge of discrimination with either of these agencies by going onto their website. And there are very clear instructions on both of those. And they'll be able to work with you to file a charge of discrimination, which will initiate an investigation and an opportunity for you to work with that agency to come to a resolution between you and your employer. But what happens if you did all of this, or you engaged in the reasonable accommodation process and then you were fired? So for example, you were not granted an accommodation and you were fired instead because your employer thought that it was easier to fire you than to accommodate you. Or you weren't able to do your job because the accommodation was never granted. And so then you were fired. Or without the accommodation, you had no choice but to quit. In all of these cases, I would recommend that you contact the Disability Law Center's intake team and see if your case does fall into any of our case criteria. And in all of these situations, pursuing legal steps on your own with either the UALD or the EEOC are both options that are still available to you. The other things that we can help you with in terms of employment issues at the Disability Law Center could be other forms of disability-based discrimination, such as failure to hire, a slash in wages or hours, harassment on the basis of disability, overpayments from Social Security due to miscommunication with your employer, vocational rehabilitation issues, and more. So all of these are things that we may be able to help you with if you contact our intake team. And finally, I want to leave you with some resources that could be really useful. As I mentioned before, the Job Accommodation Network, which is askjan.org, is a really great resource for you and for your employer. I've put up the websites for the UALD, which is the laborcommission.utah.gov and the EEOC.gov, where you can file those complaints. I've given you our own website, disabilitylawcenter.org, and you can also search for a lawyer if you need to on the Utah Bar, and you can search by practice area, what type of law that lawyer specializes in within that. So I'm going to go ahead and leave these on the screen for a moment so that everybody can see these resources if you want to take them down while I go ahead and answer a couple of questions that we've had here. So one of the questions that we have is, if a hard of hearing person uses a hearing aid and works in a job where they have to attend staff meetings, etc., and they need accommodations such as an assistive listening device, would that be considered a reasonable accommodation? That would likely be a reasonable accommodation. And I think that this is about the difference between what's a reasonable accommodation and what is a personal device. So a hearing aid you use all the time, you use it in your personal life, but because this is specifically about attending meetings and being able to hear in a large group or in a large area, that would be an accommodation that an employer would need to provide. It wouldn't be something that an employee would need to provide for themselves. And then another question is about, in certain circumstances, a change in supervisors is acceptable. Now, I want to just emphasize to everybody here that an employer is welcome to go above and beyond what is required under the law. So when we're talking about the ADA, we're sort of talking about what an employer can be forced to do through the ADA. And likely they can't be forced to change a supervisor. For one thing, some businesses are so small that there really is only one manager or something like that. So a change in supervisor just wouldn't be feasible. But if the option to change a supervisor exists, sometimes it's easier to change a supervisor than to change a supervisory style. So something like that may be a accommodation that your employer is willing to provide. So another question that we've got is it legal for the employer to require your medical physician to sign and be a part of the questionnaire, the interactive process questionnaire? There's not necessarily a clear answer to this, and I just want to clarify that when we're talking about the interactive process, while an employer might have paperwork or form that they are requiring you to fill out, they don't have to do that. That's just often an easier way for a large organization to streamline their process for the interactive process. But they don't have to get you to fill out those types of forms. They're not, going to be audited by the government. And if they don't have those forms in order, nothing's going to happen. That's just an internal procedure that will vary from business to business, from employer to employer. So if they're asking you to provide medical documentation, like I said, that's appropriate in cases if your disability isn't readily apparent, or if it's not readily apparent how the specific accommodation you're asking for is connected to that. And there are some pros and cons to having a doctor involved. On the one hand, having a doctor can be a really good resource for you. It can be somebody who's in your corner, who knows a lot about your specific disability and maybe has a lot of expertise in what accommodations might work for you. And so that can be helpful. On the other hand, sometimes it's expensive to get a doctor's letter. It's inconvenient. It may not provide anything to your employer that you haven't already been able to tell them with your own words. So they can require it in certain instances, but they don't have to require it. And I think it's fine sometimes to say, while I am able to give you a doctor's letter, you don't have to sign a general release of all medical information, because it would obviously be very inappropriate for your work to have complete access to all of your medical records. So while they can ask for a physician's letter requiring a complete HIPAA release is likely inappropriate. Please let me know if I have not answered any questions. Okay, looks like maybe we've got one more. Okay, so if the company is requesting paperwork to be filled out by the employee, is it appropriate and the employee should oblige? In general, the answer to this one is yes. So when we're talking about the interactive process, it doesn't just require the employer to interact and engage with the employee to figure out if there is a good accommodation. It requires the employee to be part of that back and forth as well. So I think ideally, a good interactive process would include some meetings where you're actually able to talk about what the best way to accommodate a disability is. But in practice, that might not be the way that your organization does things. And so what you don't want to have happen is have your employer deny any accommodation because they said that you failed to join them in the interactive process and failed to engage with them. If they're trying to figure out what the best accommodation for you is, and they need to know what specific limitations we're trying to overcome and what the different ways to do that are, that's going to probably necessitate some level of disclosure from the employee about what is and isn't going to help overcome their limitations. So it is in general appropriate for a company to request that an employee fill out paperwork or have their doctor fill out paperwork. However, the scope of what that paperwork is can vary pretty drastically from situation to situation, just based on the nature of the job, the limitation, the disabilities. But I would definitely be hesitant to sign a general HIPAA release for all medical information, and make sure that you're working closely with your doctor to make sure that any information that they're disclosing to your employer is relevant, limited, information specifically about the disability. Let me just see if there are any other questions. If anyone has some questions, feel free to type them into the chat or into, we've got a question here. Can the employee get punished for not filling out the paperwork? Well, so it depends what you mean by punished. If the paperwork isn't filled out, like I said, it's possible for the employer to say that they didn't engage in that interactive process enough. If the employer doesn't have enough information to be able to come up with a like a good or effective accommodation, then the employer may be sort of off the hook for providing that accommodation. And, you know, I'm guessing if you're asking for an accommodation, it's because you need one. So there's a real back and forth on how much engagement happens. So in general, filling out the paperwork and providing a doctor's note, it is a fairly standard part of an interactive process. But what it looks like from situation to situation and how much information your employer really needs in order to assess your request for an accommodation can be just very drastically different. And you'll kind of have to make that determination for yourself about where that line is. We've got a question here that says, is there a way for you to ask for an advocate to be present during the process of asking for an accommodation? Yeah, it's definitely possible to ask for somebody to be there present with you. One thing that an employer might really worry about in that process is confidentiality and disclosing your private medical information to your advocate. However, just because they're worried about it doesn't mean that's a reason not to ask for it and to have them let you bring an advocate. And that's because if you're bringing them, you're probably comfortable with what you're going to say in front of them. And having an advocate can in itself be a reasonable accommodation. If, for instance, you have social anxiety, maybe you need somebody else there, or maybe you have somebody in your life who serves as an advocate for you in many forums, and that's what you're comfortable with. And you can always ask them to, you know, if they're worried about confidentiality, you could sign a release to speak freely in front of your chosen advocate. Or if they feel uncomfortable with having an outside person come in to help advocate for you, you could ask them if they would feel comfortable having a different coworker be present with you, or maybe bring your own manager to a meeting with HR, something like that. So those are all great ways to ask for an advocate to be present with you. I will give it about 4 more minutes if there's any other questions here. We've got a question about, can a legal guardian act as an advocate? Yes, a legal guardian can act as an advocate for an individual. And in fact, in cases where there is a legal guardianship in place, it makes a lot of sense for the legal guardian to be present for things like asking for a reasonable accommodation or being there to advocate on behalf of the worker with the disability. And so making sure that the employer is aware of that legal guardianship is definitely going to be a critical piece of making sure that that guardianship is respected. Someone is asking about service dogs. So a service dog it is kind of an unusual situation because most of the time that people are talking about service dogs, they're talking about some of those other areas of the ADA that we talked about at the beginning of this presentation. Title II and Title III of the ADA, which are about government related places, things like, public buildings, or things like things under Title III that are public areas like movie theaters or restaurants. So a lot of the time that we're talking about service dogs just in our ordinary lives, we're talking about whether or not service dogs can come into those specific areas. And there are specific rules about service dogs in those parts of the ADA. But Title I about employment doesn't create any special rules for service dogs. Instead, service dogs are just pushed into the existing framework of reasonable accommodations in Title I. So when we talk about a service dog is basically a reasonable accommodation that's typically a modification to a no dogs allowed in this workplace policy. So when you bring a service dog, you would follow the typical request for reasonable accommodation procedures. And that would be basically the way to go about handling that situation. And when we evaluate if a service dog is a reasonable accommodation, we use very much the same framework that we use for these other accommodations. For example, is the service dog a direct threat to anybody? Is this a well-trained service dog that properly executes its trained functions? Or is this a service dog that has bitten a coworker? Something like that. So whenever you're talking about a service dog, just apply this exact same framework that we've talked about. I think we're going to go ahead and end the questions here and wind down this presentation. But I hope that this has been helpful and that you're able to use these resources that have been provided and this framework to evaluate what steps you might need to take or what steps you could help somebody else with in pursuing their request for accommodation. It's been a real pleasure to have you all here tonight. I hope that this is informative.